You are Juan Jose Serna. Mr. Serna, you now stand charged yet again with burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County.
Pause right here. This is a probable cause hearing, not a trial. The judge isn't deciding guilt yet, only whether there's enough evidence to keep this case moving forward. And what you're hearing now, this is the prosecution laying the groundwork.
County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of the parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once
this detail matters a lot. Waiting for the alarm to stop, then coming back, that shows intent. In court, intent can be the difference between walking free and facing serious time.
The alarm stopped making noise, the suspect jumped back over to the complaining witness motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to her motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking up, jumped out of her motor vehicle, got into the passenger side of a waiting vehicle with an unreadable plate, and the complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat, and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor. Yeah. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to.
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr. Serna is the second. Looks like the second individual that was in the that was in the driver's seat whenever the complaining witness came out of the vehicle.
This is a classic defense move. Attack the identification. No camo hoodie on this defendant. The defense is trying to create reasonable doubt before the case even gets off the ground.
Is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable cause.
They have both of them in the car, being car.
The both of them in the car?
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
Were in the car attempting to.
I have the.
Because I thought it read that one person wearing a camouflage hoodie was in the car.
That was the second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off. Mr. Serna, let's go through your stuff. Theft of wire or cable. Theft. Trespass, evading arrest, burglary of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft.
That silence you're feeling, that's the weight of a rap sheet catching up. Judges aren't supposed to punish you for your past, but they absolutely consider it when deciding how dangerous you might be.
assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time after time.
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at $10,000 for this misdemeanor. Can we reset till Friday to see what happens in
This is the court saying, I don't trust you. Home confinement, alcohol monitoring, weapon bans. This isn't about punishment yet. It's about preventing the next headline.
felony? I'm asking the court to not revoke his bond. His bond is set at $10,000. I'm asking the court to just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In
the
felon, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If, I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Cerner. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Do we have, who got the co-defendants? Do we have the co-defendants? No contact with the co-defendant, please, Felicia.
Still loading, Your Honor, I apologize. We have the co-defendant, Your Honor.
Say it again.
We have the co-defendant. I'll sit on the 14.
Let me ask you this. You ever had a job before? Like a full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years. All right. Good morning, man.
Hi.
Just a little bit down so I can see your eyes. That's okay. How are you? Ma'am, you've not picked up another case. You're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, if I could just confirm the name.
Agbacielo.
On April 1st, 2025, a law enforcement officer was dispatched to a residence in Harris County, Texas regarding a disturbance. Law enforcement officer made contact with the second complainant witness who stated that he was inside the apartment when he heard the first complainant witness outside getting yelled at by the defendant. The second complainant witness went outside to see what was going on, and the defendant yelled at him to stop putting things in the pothole in the parking lot. The second complainant witness told the defendant he was fixing the hole. And then threatened both the complainant witnesses, pointing at them with their fingers, making a pistol shape with their fingers, saying, "I'm going to shoot you."
Wait, you said there were 2 complaint witnesses.
Yes, Your Honor.
Okay.
That's what I have here. It says, "I'm going to shoot you," towards both complaining witnesses.
And we have Ms. Agbacielo making the alleged threats.
Correct, Your Honor.
There's only charges one.
There's only, yeah,
There's just one.
Right.
yes, Your Honor.
Okay, who is the complaining witness?
Theo Strong.
Is it a known person? Because we have priors with Ms. Iglesias and there are assaultive and, pretty dangerous priors. Any of the same complaining witnesses?
Does not appear so, Your Honor. I'm looking through. No, Your Honor. It seems like it's just, from what we can see, it's kind of just.
Was it a street worker? Was it someone working for the city or
It's someone that lives there, Your Honor.
just out there fixing the potholes?
That's correct, Your Honor.
Okay. All right, Ms. Iglesias, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand, ma'am?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer, ma'am?
Yes, Your Honor.
Okay, we can give you time. So what I'll have you do now is I'll have you sign a receipt, Victoria, while you take a seat, while we draft the bond conditions, I'll have you sign it, and after that, you'll be free to go.
Yes, Your Honor.
Please, ma'am, don't pick up any new cases. Just don't have contact with these people. I don't want to have to put you in jail,
Your Honor, it was the same thing the last time, the
Just,
last case.
just please be careful,
Yeah.
Really.
People make false allegations all the
And
time.
I get it. There's always two sides to the story. That's why you have a lawyer. That's why we'll give you time. But the evidence will point to whose side is correct.
Yeah, and I do have them.
So, please.
Thank you.
Yes, ma'am.
All right, good morning, Mr. Kyles. Sir, you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 2nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an apartment complex and spoke to a complaining witness who said that she was laying in her bed and was awoken by her son, the defendant, screaming. And then she heard 2 gunshots go off in the apartment. The complaining witness then got out of bed and took the gun from the defendant, hid it, and called 911. Upon arrival, the law enforcement officer recovered the weapon, along with 2 fired shell casings and 2 fired slugs matching the caliber of the pistol fire. Upon contact with the defendant, the law enforcement officer noticed the odor of alcoholic beverage and that the defendant was wet while fully clothed. The defendant stated he had
So, what? Defendant was what?
wet while fully clothed.
Wet while fully clothed. Okay.
Yes, Your Honor. The defendant stated he had been drinking alcohol and smoking marijuana and that he fired the firearm in the apartment. The defendant stated he was wet because he dumped a bucket of water on himself. The defendant stated that he was paranoid at the time.
Mr. Kyles, I'm sending you for a drug test. I want to know what, if anything, was in your system. You're to come right back. I will appoint you a lawyer today, but you're not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. You're also not to be in possession of weapons. Do you understand? So, do you guys have a rip done on this case? Do we
Yes, Your
know
Honor.
whether she wants him back at home or no?
I made contact with the complaining witness, Your Honor. However, she did not wish to talk with me about the incident after.
She didn't want to talk to you?
No, Your Honor.
Okay. Don't be in possession of weapons, Mr. Kyles. I don't want to have to put you in jail and make your bond high. I don't know if you have anyone in this life that is prepared to pony up $5,000 to $10,000. So when you're out there in the free world, if you don't have anyone that's going to, pony up that money for a bond, you'll be stuck like Chuck in there. So be careful. All I want is my city safe. Do you understand? Okay, so what we'll do is I'll appoint you a lawyer today. Or do you have the ability to hire a lawyer, or would you like a court-appointed lawyer?
You can appoint me a lawyer, and I may consider hiring one if the understanding is not
I
understood.
just want to know whether you want a court-appointed lawyer or not.
Yes,
I
sir.
can
Yes,
appoint you a
sir.
lawyer today. I'm sending you for a drug test. I want to know what, if anything's in your system, come back, and then I'll have a lawyer waiting for you.
Okay.
Okay, please.
Judge, financial affidavit or no?
Good morning, Judge. I'm here on Katrina Keys. You had her on docket for Friday for a bond violation, but she needed to come in and talk to you anyway, so she came today.
I'm sending you for a drug and alcohol test right now, ma'am. But unacceptable. You're on bond for DWI, and you now you're allegedly consuming alcohol.
No.
Yeah,
I spoke with the Scram people and she said that was not it. It's not an alcohol violation. She doesn't know if
alcohol
my,
was detected during both tamper events. But they cannot be confirmed because of the nature of the tamper.
I haven't had a drink since I was arrested, Your Honor. I've done everything this court has asked me to, outside of looking for a job and everything. I have had no problems. I've called Scram about my device, because I have neuropathy swelling once it goes down. So she said it was loose. I asked them. The only thing that I did on Saturday and Sunday, which can be confirmed by my GPS monitor, I went to my son's basketball game. I left my house, went to my son's basketball game, from the game back.
Let's
I
do
have
this.
not done anything.
Lisa, do you mind sending her for a test right now, please? I'm going to send you for a test. You
Okay.
come back. Do you
No problem.
understand?
Mhm.
We'll deal with the violation when you come back.
Okay.
Just please take a seat. Tell me about it.
We can just. For the DVR?
No,
Oh, sorry, her drug test was presumptively negative, Judge.
ever test positive again, I'm going to keep you.
Judge, it was a scram temper.
If you ever tamper with the device again, I'm going to keep you. I'm doing everything in my power not to revoke your bond. Do you understand? I don't care what it is. If there's a problem with your device, you need to go have it switched out, go get it looked at, but I will not entertain any more excuses from you. No tolerance. Do you understand?
Yes.
Okay? All right.
Did she address my curfew? My lawyer was supposed to ask her about my curfew because I got a job and I started today. And the job is from 5 p.m. to 6 a.m. at Igloo. And I have the letter saying that I've been accepted for the job.
Does she have something open elsewhere as well?
She had a deed to provide open at Austin County, Your Honor.
It's still open?
It's not still open. I'm not sure if she plugged it or what happened, but looks like she's on probation now. For that one at Austin County.
You're on probation for DWI. You've not picked up another DWI. I don't want you driving in the middle of the night.
I'm not driving. I'm not driving.
That was just on March 26th, I believe, Your Honor. Is when
Right,
she plugged for when that case was resolved. The year probation.
I resolved that case. And I,
You still have an open DWI and you picked up another DWI.
I didn't. I haven't done anything since before.
Don't talk. All I know is that you have a probation for DWI, you have an open DWI. The last thing I want is another death on my streets. And I'm going to do everything in my, I tell Pete, everybody tells me what I want to hear here.
I'm
And then
not.
when they get out there,
Before I took the job, I spoke with my lawyer.
It's keys.
I have someone that works there and they shuttle and I can get a ride. But right now, like I'm having a problem with getting my lights were turned off. The phone was turned off. I'm worried about monitoring. So I've been working very hard to find a job. This is the only job that I found and I need to work to survive, to pay my bills. I have to work. And with the background that I have, it's been hard for me to find a job regular 8 to 5. This is the only thing that was available. And then I made sure that there was a ride or a shuttle. They work in shifts. So 5, 6 people in my neighborhood work there. So I've secured a ride to and from work.
proof of employment that you actually have a job working
I
there.
have it. My lawyer have it and I have the
Have
email
you
right
get
here.
with your lawyer? I want to see actual proof that you're working there. And then we'll put a GPS monitor on you,
I have a monitor. I have GPS monitor already.
exact address, so that we know that you're going to and from work. If you deviate in the slightest, and I don't care what it is, that'll be your 3rd bond violation, and I'm going to lock you up. I will deem you a public danger and make your bond sky high. Do you understand?
Yes.
Okay.
The-
Chief Marie, I'll have you get with your lawyer and then they can get with pretrial.
And I start today. It starts today at 5 p.m., which is why she had me come today.
Okay.
Cool.
I'll have you get with Ms. Reedy. She can get with pretrial. You guys can work out the details.
All right, thanks.
Judge, would you like me to email that proof of employment to you or to pretrial?
No, to Felicia. And I
Okay.
don't know if you have her email address. I'll see if I can get it for you.
Okay, please. I'll see if I-
Give me a second. I'll chat it to you. Hold on a
Okay,
second.
thank you, Judge.
Good morning, Mr. Williams. Sir, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 15, 2024, in Harris County, Texas, a defendant was observed on surveillance video entering a pawn shop accompanied by a female, a toddler, and a baby in a car seat carrier. The defendant was observed putting down the baby, picking up a projector, and concealing it behind an item on the next aisle. The defendant then returned to the baby, picked up the baby, and then picked up the hidden projector and concealed it in the car seat. The female completed a transaction at the counter, and the defendant left with the item in the car seat without paying, passing all points of sale. The defendant was identified by his Tennessee driver's license photo by the complaining witness. The value of the item stolen was $2,000 or $2,099.99.
Do we know if they got it back?
I do not, does not say in the DIMS. I need just a moment, Your Honor, to.
We can worry about it later.
Yes, Your Honor.
Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this pawn shop. You've also missed 3 different times. If you miss, excuses go in one ear, go out the other. Actions are what matter, Mr. Williams. You've missed court on 3 different occasions. If you miss again, I'm going to make your bond so high, it's going to hit the clouds. Do you understand? Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll take a look to see whether you qualify. Okay. You get, every time you bond out, they give you paperwork telling you where you need to go, the date and time and the location. So I'm not going to argue with you, man. It's just, we've had 3 different occasions. Your case is 220 days old. So I'll have you fill out an application. I'm going to have you sign a receipt. I'm going to have you take a seat, but I need to do further bond conditions on him. So you're not allowed to leave until we do further bond conditions. Please, please.
We're approaching on Sean Williams. He's on today's docket.
This is the gentleman, it's a theft of the projector from, okay.
Victoria told me I needed to approach about bond conditions,
Said you wanted more bond conditions.
but if you're happy with them all,
Well, no, the thing is this case is super duper old, right?
yes. And the judge, this was a 2B. And so that's part of the age. And then,
If it's a true 2B for
Well-
like 180 days, then I don't have a problem. But if he's been on bond
Well-
and then he takes off for 150, then
so just my brief look at it, what looks like happened is it was a 2B. He got picked up. He paid an out of county bond. And his next court date was not clear to him. And
come on.
so, he did bond forfeit. And then he paid another out of county bond and he's here today.
Yeah, he's forfeited at least 2 different times. It's now 212 days old.
It looks like to me, he's only bond forfeited once.
He's made,
You're concerning me, man. It's a concern.
And again, any amount of bond forfeiting is bad, but
discovery complete on this case.
Hold on, Your Honor. Verify that.
If you ever take off on me again, Mr. Williams, you know what's going to happen to the bond. And if you don't have anyone in this world that's willing to pony up 10,000, perhaps 5 to 10,000, you will be stuck like Chuck in there until this thing is over. Do you understand me? The only thing in this world I'm asking you to do is keep my county safe and show up. You pick up another case, you are unsafe to my county. It's really not going to go well for you. Do you understand me?
Do believe this, Your Honor, there's.
I'd like you to do a writ first as well to see whether they got the projector back or not.
Yes, Your Honor.
And then,
Judge, if we can just have a regular reset,
your regular reset.
that'll give me time to look at
You
everything.
must be here at the next setting. So we're going to decide what we're going to do with this case. But I'm going to tell you now, if they didn't get it back, it will be part of anything. That
Understood.
restitution is, all right, Mr. Williams, don't have any contact with these people. Don't have any weapons. Don't pick up any new cases. So I guess Felicia, I'll have you do it as just because it'll be faster so we can get them out of here. Just no contact with the complaining witness, no going back to the pawn shop, no new cases, no drugs, no alcohol. Okay, all right, dude. Good luck. See you in 30.
Okay. Okay, so I have talked to pretrial in regards to the violations as to tampering with the scrum.
You need a translator anyway, right?
I guess
Enrique
so.
Ramirez?
Yes. So, pretrial doesn't know exactly what was tampered with. He does work in construction. He wears boots, he wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says that scrum actually has been causing him a lot of pain on his legs. So sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no like BAC, no alcohol, nothing. It was just
Because a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor to, evade. This is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 a.m. so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
The first one.
Here's the hard truth most people don't realize. When you sign parole or probation paperwork, you often waive extradition rights. That signature, it follows you across state lines, sometimes years later.